I've never been in a courtroom before. It's quite intimidating. Can you explain who sits where?
Sure, it's actually quite organized. See the elevated desk at the front? That's where the judge sits. It's called the judge's bench.
And what about that small stand next to it?
That's the witness stand. Witnesses sit there when they're giving their testimony or being cross-examined.
Good afternoon, my name is Felipe Velez, and this is Legal English. Well, today's class is going to be very special. Today we're going to check what are the rights of the plaintiff. Yesterday we checked about the rights to have or to be seen by the defendant. Now, when we're talking about the defendant, remember we talk about the person being accused. So the person being accused is going to have the right to have a counsel, the right to have a lawyer, the right to file motions. So in this class, we're going to see how are those favors, how are those considerations now ruling in favor of the plaintiff. So repeat after me, please. In the court. Again, in the court. Can you hear me, Ulises?
Yes, in the court.
Very good, thank you. So we're talking about names and actions, and we're going to check some legal idioms. So let's go to the first one. What are the rights that they're going to be for the defendant? Pronunciation, plaintiff.
Plaintiff.
Is the person who brings a case against another in a court of law.
Is the person who brings the case against another in a court of law.
Okay, continue. Defendant.
Defendant, an individual, company, or institution sued or accused in a court of law.
Very good.
Judge.
Very good. Now, judge.
Judge, a public official appointed to decide cases in a court of law.
Very good. Jury.
Jury, a group of people, usually 12 in number, sworn to give a verdict in a legal case on the basis of evidence submitted to them in court.
Very good. So a verdict is a decision on a disputed, pronunciation, disputed.
Disputed.
Issue.
Issue.
Very good. So pronunciation, please. Verdict.
Verdict. A decision in a disputed issue in a civil or criminal case or an inquest.
Excellent. So let's see who is going to be who. So the jury is going to be over there. Yeah. The jury cannot be seated over here. That's a prohibition. Okay. Here we're going to have the party. We're going to have all the people that's going to be represented by public in general. So we can call them bystanders. We can call them just a person from the people. So we can also say somebody that is willing to observe. So you can also say, I come here to observe. So you come to observe. Yes, as I come to observe, I'm just it's because every decision is public. So anybody can observe a matter of the law. So again, pronunciation, plaintiff.
Plaintiff.
Defendant.
Defendant.
Judge.
Judge.
Jury.
Jury.
Very good. So the jury comes here and they stay there. Very good. Next, let's see the plaintiff rights. So the plaintiff rights are going to be a little different from the defendant. The first guarantee that the plaintiff is going to have is going to be the right to a fair trial. Again, pronunciation, the right to a fair trial.
The right to a fair trial.
Very good. The plaintiff has the right to a fair trial, which is a fundamental principle of justice in democratic legal systems. This includes the right to have the case heard in a competent, independent, and impartial court. So that's the important thing about court, to be or to have a fair trial. This fair trial, we call it a due process of law. So the due process of law, it also extends that the parties can be assisted by a counselor. The next thing, or the next right that we're going to have, is the right to legal representation on the right to counsel. The right to legal representation, plaintiffs have the right to be represented by an attorney. So you see, so not lawyer, so we say attorney. If they cannot afford one, depending on the nature of the case and jurisdiction, the court may appoint a public defender or provide access to legal aid. So the victim doesn't need to pay for the aid, yeah, because she is the victim. But that changes with the jurisdiction and with the states. There are some states that establish that if you're the one that is accusing, the burden to pay for a lawyer, it's on your hands, okay? So we're going to check what are those states and how it's going to be liable or not. So the plaintiff is usually the victim, and the right to present evidence and witnesses. He has the right to present evidence and witnesses. Again, right?
Right to present evidence and witnesses.
Very good. So the plaintiffs have the right to present evidence and call witnesses to support their case. This includes the ability to subpoena. Again, pronunciation, subpoena.
Subpoena.
Subpoena is to call people. It's a citation, but in the name of the plaintiff. Okay, so they're gonna ask the person to come voluntarily, willingly, or by a judge order. Okay, again, pronunciation, subpoena.
Subpoena.
Witnesses.
Witnesses.
Very good. And documents
And documents
that are pertinent to the case.
that are pertinent to the case.
Very good. So that's very important. The plaintiff, if he doesn't have enough evidence, he can create the evidence. But whenever I say create evidence, it means to request it by the judge using a subpoena. Again, pronunciation, subpoena.
Subpoena.
Very good. So every time that you have or you receive a subpoena, it means that you need to provide a document or a testimony for the judge. But the judge is going to hear it in something that we call discovery. Understood?
Yes, understood.
Thank you. Next right, we're going to have the right to a jury trial. Again, pronunciation, right.
Right to a jury trial.
In many legal systems, plaintiffs have the right to request a trial by jury, particularly in criminal cases and significant civil cases. This right allows a group of peers to determine the outcome of the case based on the evidence and arguments presented. So it's kind of the same right with a criminal trial, but in this case, it's not only a right, it's an obligation in case we don't have enough evidence. So that's why it's always the jury that's going to decide everything. So what's the last right that is going to be on the plaintiff? And that is going to be the right to appeal. Again, pronunciation, right to appeal.
Right to appeal.
Very good. So the plaintiff considers that the verdict dissatisfies the outcome of the trial, they generally have the right to appeal the decision to a higher court. So if we have an appellate court, then you may assist or you go to an appellate court. This is an essential aspect of ensuring checks and balances in the judicial process. Again, pronunciation, that's a very important idiom. Ensuring checks.
Insurance checks.
And balances.
And balances.
Yeah, this phrase comes together. Ensuring checks and balances.
Ensuring checks and balances.
It means to have this balance of the law real shape. That's an expression that we use. Good afternoon. My name is Felipe Velez, and this is Legal English. Well, today